problem. All right. Hello and welcome to the Modern Divorce Navigator Live. I am so glad that you're here. This live session is designed to help guide you through complex, emotional, and often overwhelming process of divorce and family court. So whether you're just starting out, you're deep in the process, or you're working through your issues, our goal is to empower you with educational tools and clarity to make so that you can make informed decisions. But we have a few confidentiality disclaimers. This session is for general informational purposes only, and nothing here should be considered legal advice, nor does participation create an attorney client relationship. Every divorce and family law situation is unique, and the laws and outcomes can vary based on your jurisdiction. So, I strongly advise you to consult with a licensed attorney in your state. This is a public educational environment, not a confidential one. So do not share personal, identifying, or sensitive information about yourself, your children, or your finances that you don't want here to be public. We're here to educate and support you, and today's office hours are live, so you can ask me whatever you'd like. My name is Billy Terrasio, Arizona family law attorney. How can I help today? Nancy, do you want to go first?
Hello.
Hi, Nancy. How are you?
Good. How are you?
Doing great. Doing great. What's going on? How can I help today?
I was the one with the enforcement of the court order, and you told me to try and dismiss it last week.
Mm-hmm.
So I called your guys' office, and I never heard back from them. So I
Oh
never did
no.
get a chance to dismiss it. Um, so I ended up just contesting to it.
Well, yeah, I saw that you
So
posted in the Navigator that you had already filed a response, right?
no,
Right?
I didn't find, well, I did yesterday. Yesterday I did because I never heard back from the lawyer to dismiss it. So I ended up just contesting to it yesterday.
Okay.
Um,
You filed a
so
response.
I was 11 minutes late, unfortunately.
Okay.
I was trying to get on it and then it kicked me out. So then I had to try to get back on it. And she was ruling, I think, in his favor at the time.
Oh
So
no.
she pretty much just like scolded me for being late. And
Mm,
then, she told us what to do with like I have to hand in evidence and I have to make a pre-hearing statement. Now I'm wondering with the evidence that I have to put in, how do you, how do you like break it down? Because with his, like everything that he's asked or everything that he's stating, do I just send text messages in for each of those things that he's stating that I did, or
yeah, you're gonna want to refute those allegations one by one.
okay? And with like the extracurricular activities, like I did put our son in extracurricular activities without with him saying no, but it was during my time.
Yeah.
And then the first time I did it, he actually did go to him, and I tried to get a note from the coach, but he doesn't really want to be involved, which I get.
Yeah.
So I was wondering, can I get a note from my parents because they were there and they did see him there?
I don't think that
Would
that
that be
matters. So you are there on a contempt and enforcement, and there's nothing in the order that prevents you from signing your child up for sports. That's kind of the end of
okay?
story.
Okay, because I was trying to prove that he actually did go, and he's stating that he didn't go. He didn't, he didn't want to go. He didn't approve of it, but he was actually there.
Right, right. I mean, you can certainly testify to that. You could have your parents as witnesses, be there to testify to it.
Okay. And then what is a pre-hearing statement?
Yeah. It is a document that gets filed with the court that has all of your legal arguments, all of your exhibits, all of the facts. It's probably the most important document in your case. So I often say if you're going to pay a lawyer to do one thing, have them do the pretrial statement for you. But if you're not going to have a lawyer do it, then make sure that you take the courses on trial strategy, that you put together a trial binder, that you are prepared to represent yourself in court and make a really good pretrial statement.
Okay. And can I do that through you guys
Yep,
with the
yeah,
lawyers?
absolutely. And I can have my team reach out. I apologize that they didn't get back to you. And if that ever happens again, definitely message us on that Navigator website. But um, uh, yeah, Kendra said she's going to reach out to you.
Okay, awesome. Thank you so much. I appreciate it.
No problem. Nicole,
All
how
right.
can I help today? Are you there, Nicole? All right, let's go over to Kendra. How can I help you, Kendra?
Hi there.
Hi.
A couple, I don't know, a couple months ago, I had asked you about child support because my ex hasn't made a payment in almost a year now. He changed jobs, and you advised I should just grab my withholding order and send it to his new employer. So when I go online, it's not on my ECR. And I can see on the docket there's an income withholding order, but it says restricted access. So I'm just
Okay.
wondering how I can actually get a copy of that.
Um, do you have an ECR account? Is that where you're looking?
In my ECR, there's not even like an entry for it. I can only see it on the docket.
Interesting. I don't know why you can't go get it. I don't know if you could get it at the courthouse. I mean, you're entitled to access the document.
Okay.
You might
Do you
even
know?
call the clerk and find out why is this restricted.
Okay. So that's not it, not common that that would be
No, I
restricted.
mean, no, you should not be restricted from seeing anything. You know, unless a judge like specifically restricted like a confidential child interview or something like that, but like it doesn't really make sense to me that this should be restricted from you.
Okay. Okay. Thank you.
Yeah, you're welcome. Mickey, how can I help?
Hi. I didn't really have anything, but
Okay.
since it seems like there's a little time, I'll go ahead and ask. I had asked you last time about um, my daughter's dad filed income taxes with her social security number, and then I filed and mine got rejected, and then I got a pin and refiled mine, so now mine are in process too.
Interesting.
Is
Okay.
anything will and who, if anything, will flag that both of us have claimed her?
I mean, that's really an IRS question more than a family law question.
And last time you advised not to do a separate contempt of court for that because I mean he was offering to pay me
Right.
separately or to do something else, but
Right.
I had already filed mine and I didn't want to go back and do an amendment to mine, so I just filed mine like I'm supposed to. So can I
Mm-hmm.
still include that as a contempt of court? I mean, he did not follow the orders.
Is he paying you the difference?
No, I just filed mine as I would. Like I didn't even. I mean, they asked me for. I had to go in and request a specific PIN number saying that I was authorized to claim her, and so I did that, and
Mhm.
then it went through. So I just
I
left it
mean,
at
if
that.
you file for contempt and he says, I offered to pay her the difference, you're not going to look good.
Okay.
Because what if
Even
you
though I would,
your
I mean, I would
profit?
have to go through the process of filing all the amend taxes and do all of that myself. Like that's extra cost and time and everything to me because he screwed up. I
Did
mean,
he
it worked
offer,
out, but
did he offer to cover all of that?
no, he didn't really offer anything. He said, "Here's your two choices. You can
Mm-hmm.
take her next year or or I'll just pay you."
Mm-hmm. And now your filing is going through. So you're wondering if you can still file for contempt?
Yeah. I mean, I don't need to file for contempt, but I guess my purpose in saying that is that's one of 3 contempt charges. The other one
Mm.
is he's I have final decision making for
Mhm.
medical, educational, legal, and
Mhm.
this is a constant thing with him. But
Mhm.
the last 3 issues are he scheduled eye doctor appointment after I had already scheduled one, and so I canceled mine. He wouldn't tell me where he was taking her, and then he took her with his wife. She basically pretended to be me, and they had the appointment. He didn't even provide the proper medical history information on my daughter. So the evaluation that they did wasn't incorrect. She's had eye surgery, so there's history there. Um, and then told me, oh, it's my mistake. Here's the information that we received from the doctor. Like we went. So I kind of wrote that off. I mean, I wrote it off in the sense of like, there's nothing I can do about it right now. I got her a new doctor. I went to the right place and we went through the right thing. So that was 1. And then 2 was the taxes. And then 3 was um, the other day I'm trying to get her into counseling. I'm trying to get the pediatrician on board to refer it so that he doesn't have as much issue to fight me on it, even though legally I can do it, but the counselor is still going to want both of us to agree to it. And he's
Right.
refusing, which in and of itself tells you that there's issues if he's refusing a 7-year-old to go to counseling.
Right.
Um, and she's exhibiting issues already. She's the 4th of my children, so I've already been through some of this. So I've seen it.
Right.
But anyway, so that we're at the doctor's appointment. It was my custodial day, but he refused to let me take her. That was our switchover day, and he refused to let me take her and started to cause a scene. So I was like, "You're violating our order. Like I'm supposed to get her at 8 a.m." I had already made plans with her to drop off stuff for the teachers when I was taking her to school. So that was the importance of it. But I just like I'm not causing a scene, but I texted him officially saying like our turnover time is at 8 o'clock, and he goes, "Well, our orders are vague. I'm taking her," and he just flat out refused, and it's causing issues with her too, of course, because then she says, "I'm not going with you. I'm going with Dad. He already told me." It's just causing this whole like alienation thing. But so that's the third of the issues. That's just in the last couple of months. So this is
Mm.
like a constant thing. So really, I'm not looking for like another slap on the hand and contempt of court. I'm really looking for somebody to say, like, you continue to not follow your responsibilities and the court orders. And so when I went to the free day there, the pro bono day, she recommended that I just file all of this within my modification and just ask for sole legal decision making.
Yeah. I mean, that is absolutely an option, that you just ask for soul and include all the reasons why you need soul. In some ways, that's a better remedy than contempt. I mean, contempt gets you a finding of contempt.
Yeah, and does that, I mean, he already has 2 contempt
Right.
charges.
And what has happened?
Nothing. He gets slapped on the hand, and I end up
Right.
having to pay all the filing fees and all the time
Mhm.
spent on everything. And that's why I'm just like, I don't want to, but he knows, so he just continues to do it and get away with it. So it's like, what do I do?
Right. Yeah. I mean, you're in one of those very difficult situations where a court cannot make someone behave well.
Right.
You could go back for contempt 25 times and it's not going to change who this person is. You know, maybe, so you have to decide, is it worth it to me to just file for contempt every single time until a judge gets so sick of us that something happens, or let it go? Those are kind of the only 2 options, right?
Do you think with that kind of history and asking for sole decision making, just because, I mean, the big things are like going to the doctor and getting these things set, it's such a hassle, more than a hassle. It's so, it, it's just takes forever to get her appointments and to get things settled, and then we show up and it's just not for her, right? Like it just gets sidetracked because of what he wants to do and overrun the situation. So do you think that purpose of asking for sole decision making is worth it,
And you
or
have final
possible,
right
even feasible?
you have final decision making right now.
Yeah.
I mean, the thing about soul versus final is you can do things without notifying, but a judge is not very likely to grant somebody that sort of authority here in Arizona who's
Okay.
involved. Do you know what I mean?
Yeah.
Now, this is not true in every state. In Oregon, unless both people agree to joint, somebody's getting sold. So, but in Arizona, if you have involved parents, it's hard to get a judge to say you don't have to tell them. You don't have to give them notice. You don't have to get their opinion. That's a very difficult thing.
And I don't even really care about that. Like I always give him notice of when I have something scheduled, or, I'm always, I don't have a problem with that. Like I try to involve him as much as I can. My problem is then when he starts going in and signing forms and giving his wife medical authorization, or,
Yeah. Yeah.
things like this is like, you can't do this. Like I'm standing right here. I'm her mom, and he's literally doing it in front of me, and I'm like, then I feel like I have no leg to stand on.
That is the most strong one of your three.
Okay.
Mm-hmm.
Yeah, and I guess more of it is I don't even really care that if I get sole decision making or not, because ultimately what I wanted to be able to make doctor's appointments, and then her, because she goes to private school, to be able to make that decision, and that's already done. So like it's not really a matter of making the decisions. But I have to get a bunch of modifications done to our parenting plan because it was written so vague, and he's one of those that the judge literally had to write the definition of what summer vacation meant because he was arguing about when summer started. And the judge finally was like, okay, this is the day it starts. Like, we're just going to write it out. And that's the level of detail that I need because, like I said, he said, oh no, our 8 a.m. transition, that's vague. I'm taking her to school. So it's like, it's not
What about
vague.
8
You're just
a.m.
not
is
following.
vague?
I know. Yeah, exactly. Like if it's 8:05 and the school calls me, I'm responsible for picking her up. Like that's not vague.
Not
So
vague.
he's just doing it to be a butthole. But anyway, so that's just where I am. Kind of just my
Okay.
stories. Thank you.
Thanks, Mickey. Let's go over to A Nieto 11.
Hi, Billy.
Hi.
So I am going through everything. So I just kind of had some questions that I would like to ask here versus asking my attorney and having to like pay for this. So we filed the on Tuesday, filed the appearance of counsel.
Mm-hmm.
Okay, and then so the plan when we had our strategy session a couple weeks ago was to file for emergency sole decision making. So I was just kind of wondering like what I should expect from that. I guess I'm not really like understanding or like understood exactly like I'm learning like nothing in legal or with the courts moves fast. And like it's so I'm like what should that look like or
I mean, if there's a plan to file for an emergency order, that should happen right now.
okay. And then once we file the emergency sole decision making, what's the typical timeline for that? Like how quick do we like is there usually a
So that's an ex parte filing, which means the other side doesn't have a chance to respond before the judge will grant or deny your request for this emergency order. And the standard is very high. You have to prove immediate or irreparable harm to your child if the judge doesn't issue this emergency order. So they're hard to get because the judge is going to take away the other parent's rights without ever hearing from them based on the severity of the things that you're saying.
okay. So do I have to even go to court or see the judge or does my attorney
No.
just submit all the evidence and everything and then they make a choice?
Yes.
Okay. So, I mean, hopefully we have enough. The he still hasn't received like a retained counsel as far as I know, and the diagnosis, the autism diagnosis is due to be released May 7th if he doesn't get the court order to block it. And when I had like when we received that email from them, I was like, "Hey, like unless you're gonna like retain counsel, like can you please stop this if you want to get a second opinion? Like I support that, but like at least let me get him started with some resources." And he said, no, like I'm getting an attorney and I'm going to fight this and whatever. But then he hasn't done anything as far as I know. So
Yeah.
is that going to help me at all? Or is that just, does it matter?
Is it going to help you get an emergency order?
Yeah.
No, it should have no bearing on the emergency order.
Okay. All right. Well, and
Yeah,
I didn't
the
know just
emergency
hearing
order
you.
will be. Mhm. I mean, you already have final decision making, right?
Yeah.
Yeah.
But
Um.
I'm also dealing with the same situation like what Mickey was saying, whereas like I'm trying to get, or like my 6-year-old is already in therapy, but his therapist is transitioning to a new role. So I need to get him with a new office. And I can't do
Mm,
that because dad continually tells me he doesn't consent. So
yeah.
luckily she's like working with me and continuing to see him right now, even though
Mhm.
she's like moving to this other role.
Mhm.
Should I just continue to like vet other therapists and then just send him my options and just even though he's like no 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 just like keep
Yep.
communicating and being like well this is what I'm doing and then show that he's denying consent?
Yes.
Okay.
Yeah, that's exactly what you should do.
Okay, I just didn't know because I don't want to look like he keeps saying that I'm like high conflict because I'm still pushing and I'm like I'm not high conflict. Like I just need you to consent so we can like keep our kid in therapy. He did end up signing the paperwork for the social worker at school. He did end up doing that last week. I was like shocked, but I
Yeah.
had the teacher reach out to him. So I don't know if that helped, like having someone else be like, "Hey, this would be
Very good.
great for your son." And then all of a sudden
Mhm.
he wouldn't tell me he did it, but the teacher told me. So I was like, "Great." So she reached out to us this week. So hopefully that also helps. Um okay. So then I think, and then I just had one more question. So the right of first refusal, that is like an actual like I don't know if it's necessarily like a document, but it has to be said like in the parenting plan, right? That's not
Yep.
just like the base foundation parenting plan that comes from the Maricopa County like packet, like mentions on there something about like you should ask the co-parent like if they can take the children or something, like give them the opportunity to take the kid or something, but it's not like an actual right of first refusal. It just is like one of those check marks that you have to check of like, you say you won't talk bad about the parent, you say that you'll work together. You know what I mean? And so
Yes.
he's saying that that's like right of first refusal. So I have like a work conference I have to go to in August, and he's like, you have to give them to me. Like it's required by the paperwork. And I'm like, it's not. And
Are
he's
you going to
like,
be
you
gone overnight?
yeah.
And who do you want to leave your kids with?
My sister. But it would just be like one overnight. Like I think they would come home and then I would come home the next day. Like the way it works. So
Mhm.
like they would go to her and then I would come home the next day.
Yeah, if there's no right of first refusal written into your parenting plan, then it doesn't exist. And it's
Okay,
your
cuz
fault.
I just don't want to have to rely on him cuz then he can change his schedule at like a moment's notice, which he's done before. So I'm like then that puts me in a bad position.
Hmm.
Okay.
Yeah.
Okay. Well, if you have more time, I'll come back around, but I'll let someone
Mary,
else go.
Mary Alice, how can I help today?
Hey, Billy. Okay.
Hi.
Hi, I'm trying to see where I can start here. I think for me, so I have court coming up for a status review hearing for the kids at the end of May. And one question I have, so back in September, there was still a restraining order in place against me. And so the judge allowed me, or the judge gave me equal physical and then said that I can go to her home away or her home games and that but I had to go alone. Okay, so since then in February, the physical restraining order was dropped and that no harassment one was put into place.
Yeah.
At that point, the judge gave me equal legal and equal physical and alternating weekends with Adriana. So I've been going to all of her soccer games or as many as I can go to. So my ex is telling me that I'm not supposed to go to her away games because it's in the court order. But what's funky about that is that on the weekends I have her, she has away games. When I have her, am I supposed to just drop her off and pick her up after the game? So does that still stand? Because he's kind of almost threatening me
Well,
that,
that's from the last court order, right? Not the most recent court order.
correct.
Yeah. So I would take the position that that provision is no longer in effect.
Okay. Okay, same thing. So there's no orders related to Emily at this time. So I've been attending her soccer games, her flag football games, because there's been alienation going on, so I'm trying to connect with her in that way. And it's been going really well. Like I'm talking to her, we're having small conversations, trying to get her to come to a visit, but we're still working on that.
Yeah.
There's nothing preventing me from going to those games to
No.
support her, right?
No.
Okay, how about her
Hey,
graduation
congrats. That's
dinner?
big news.
Thank you. Thank you. The only thing that I'm facing when I'm doing this is, for instance, yesterday, I went up to her after the game. We gave each other a hug. We talked about her graduation dinner and stuff. And I asked her, would it be okay if I attend? And she said yes. And his mom was there and she's yelling at them like, we gotta go, we need to go, because she's trying to stop the conversation. And it's becoming an issue. Now I know that there's nothing I can do to like keep her away, but is that something that I should mention in court? Because it's like she's okay.
Well, it's time for
She's,
you to get time with Emily.
yeah,
At a minimum, it's time to get an order that says that dad and his family are prevented from interfering with your conversations with Emily. But it would
got
be
it.
better if you could get actual time where dad has to leave.
Okay. Would they do that? Like he would have to leave the soccer game or whatever game we're at, kind of thing? Or how would they handle that?
I mean, it depends on what type of parenting time you want to ask for. But essentially, what I meant is when you have parenting time, dad can't be there. And
Okay.
you need time with your daughter without him and his people up in her ear, up in her business.
Like, I don't mind him going to the games to support Adriana, but it's during my weekend and I'm already on very limited time with her and he's
Mm-hmm.
there, you know?
Mm-hmm.
So, okay. Um, Lastly, let's see. So it's okay if I go to her graduation dinners.
Mm-hmm.
Like I don't need to have an order for that or right?
Right. Nothing's
Okay.
preventing you from doing that.
Okay. And the judge did say that I can make contact with her. So, okay. I think that's it for me right now. Oh, do you suggest, so this is going to the business stuff, right? The assets, the business, the house and stuff like that. So I believe, or I heard that his mom is driving one of an ice truck and has a worker with her delivering to our accounts. Should I depose her as part of my discovery for the trial for that?
Will she tell the truth?
She won't.
Mm. And then you'll just prove she's a liar. I mean, I like depositions a lot. I think they're incredibly valuable tools.
I also know that she doesn't work well under pressure, so I think she might, say things she's not supposed to or get frazzled or, that kind of thing.
Mm-hmm. Mm-hmm.
Okay. So you're thinking like a deposition would be the best way to go about it to get information from
Yeah,
her?
and you may want to record it too, because you're allowed to have a video deposition or just oral. And, if you think she's going to lose her stuff and look like a big fat liar, you may want that on video.
Okay. Okay, cool. I'll hang tight just in case I have anything else.
All
Thank
right,
you.
sounds good. Bridget, how can I help today?
Yeah, hello.
Hi.
So I have my evidentiary hearing next Thursday. We talked a few months back. So originally I do have sole custody. My ex was put on a phase up plan, which was 3 phases back in 2017, and he still hasn't completed those phases.
That's right.
But now we're going back to court for a modification hearing. And so originally our youngest was 3 at the time of our divorce, and now she's almost 13. So I feel like she is in a position to have like more say, and obviously she's developmentally like into other things like sports and stuff like that. So I sent over proposals. Well, I guess first I'll start out. We were ordered obviously timelines to turn certain things in. The timeline for discovery, or no, our initial disclosure statement was due on April 8th. And I had sent them, so there's a lifetime no contact. And so his new wife is our intermediary. And so I sent a
Good for
message.
you.
Yeah, it's very complicated. So I sent a message in our family wizard to the new wife, just letting her know, like, hey, I sent over my initial disclosure statement. I haven't received yours. When can I expect to receive it? I also haven't received like your AFI and or any discovery documents. Like, when can I expect those? Like, the due dates were the 8th. And I waited 2 days because I was like, well, I'll just wait 2 days. Maybe like they didn't realize I had sent mine over. Like, I waited. And so I waited until Monday to send it. She sent back a message saying that like I was bullying them, that I didn't know the timeline, that I was now harassing them, and they were now going to be requesting like a psychiatric evaluation. So I'm like, okay, whatever you say. Like, these are the deadlines. I don't know what else you want from me. So I just kind of
Right.
didn't respond at all.
Right.
I did file like a statement of
Compliance.
yes, with the courts. Just letting them know that like this was the deadline. I haven't heard anything. I had originally sent over a proposal to try and have, settlement discussions by the due date. I actually sent it like 3 weeks in advance. I sent it right after our resolution management conference, and I didn't hear anything back by that deadline. So like just kind of updating the courts on that. I still don't have anything from them, and court's on next Thursday. So I'm like, I don't know if I should make a big stink about it when I go to court, or I should just leave it, because I don't want to seem like I'm
Well,
being.
what do you need? What do you need that they have?
Honestly, I don't even know what they plan to
Nothing.
present.
Nothing.
Yeah.
So your strategy is to object to the admission of their evidence.
Okay, and that's not going to seem like anything, because I know that.
No.
Okay.
You haven't had an opportunity to review their proposed evidence. You even reminded them. You went out of your way to ask them for their evidence, and they failed to send it. So what you want to ask the court is that they don't let it in. Now the court might let it in anyway, because they are required to consider any evidence related to the best interest, and they often like to be really liberal with parties that they're gonna rule against anyway.
Yeah.
So I wouldn't worry about it.
Okay, and then my next thing is that originally in his request for modification, he put he was requesting joint custody now. I've always had sole custody because he went to prison, so there was obviously domestic violence, and then that was ruled in the beginning that it was severe domestic violence, and so contact was limited, and then later on with Kaylee's law, the lifetime no contact was issued. And
Yeah.
so I don't feel like I really need to have an argument for that, besides, that there was a history of domestic violence, and I
Yeah.
did submit that old criminal case.
Yeah.
But I just want to make sure like there's nothing else that I should be bringing up to make sure like I retain that. He also relocated like 200 miles away, and so that's why I'm kind of like, it's silly now that he's trying to get like educational rights when my kid's been in the same school district for 7 years. Like,
Yeah. I mean, you have a very strong case.
okay.
He's precluded from having joint legal decision making based on his history. He's also precluded from discussing anything with you.
Yeah, okay. And then the next thing I know we had discussed before was he has part of his current phase up requires sobriety, and you had requested the sober link. So to kind of show evidence that he was drinking, I had videos and stuff that was provided. One video was provided from my 13-year-old to her older sister, because we have 3, but he doesn't have access to the older 2. And that was decided like in court. It was just the youngest that they felt could kind of adjust to the changes in implementing him back. And now they're saying that like I'm stalking and using the child to spy on them. Is there any argument I need to have? Because the video that I submitted was sent to her sister. So like,
That's just what you say. Like, she took it upon herself to take this video and send it to her sister.
Yeah, okay. Yeah, because it was like 11 o'clock.
You asked her to do that. There's no evidence that you asked her to spy. How is he going to prove that your 13-year-old didn't just act of her own volition?
Yeah, well, and that's my thing too, is I was like, well, how is it getting twisted on me that I'm the bad guy here when you're not supposed to be drinking, and she has a video of you guys drunk and slurring your words. So
yeah.
Okay.
Yeah, you let the judge know. I think he's focused on the wrong thing.
Okay. Well, that was all of my questions. I guess I'm just getting nervous for next week, so I just want to make sure my thought process was, logical here. So thank you.
Bridget, it is not easy to represent yourself in court against someone who has been severely abusive. So be kind to yourself, and I hope you're proud of yourself.
Well, thank you. I appreciate that.
Callie, how can I help today?
Hi. Yeah, I have a question. I need to see if there is any procedure or way to request from the court for the judge to ask for a custody evaluation. The situation I'm in is that our parenting plan essentially flip-flopped 2 years ago when the economy tanked and the rental prices doubled, and I could no longer afford to even like house the kids in the same size house because of the prices. So he had a house. I wanted to make sure that they had like a roof over their head until I was able to provide better housing, bigger house that could house all the kids. And the goal was just verbal that as soon as that took place, the custody would go back to the way it was, since I was primary custodian after the divorce, as well as I was a stay-at-home mom for most of the time during their upbringing. So that's what they were used to. We're now at a situation where he is fighting that swap back, and the things that are going on in his home that are affecting the kids in a negative way, like mentally speaking, are very difficult to prove in court because it becomes like a he said, she said situation. I had requested of the judge to do like a child interview, and the judge told us I will not order a child interview unless both parents sign a waiver to see the interview, which I totally understand, to protect the kid from any backlash. I understood his reasoning on that. My children's father would not waive his rights for that interview. So he had assigned a best interest attorney, which I misunderstood how that worked. It was apparently just for only the reason we were in court at the time, not for the case itself. So as soon as that issue we were dealing with, which was like a child support and transportation issue, she was off the case. So what I'm dealing with now is everything that's going on. The kids have essentially no voice. I have a 16-year-old, a 14-year-old, almost 11-year-old, and a 7-year-old. And my 16-year-old doesn't want to live there at all, but doesn't want to leave her sisters in that situation. My son is outside this case essentially because he is involved in a juvenile case. So he's kind of outside, but he's living with his maternal grandparents, my parents. And that's kind of complicated the case as well. It's been high conflict from day one. It's never been an easy co-parenting situation, but go ahead.
Several things that I'm thinking. You could file a motion to appoint a court-appointed advisor. You could file a motion to reappoint the best interest attorney.
What's the difference between a court advisor and a best interest attorney?
A best interest attorney is an attorney who is supposed to represent the children. Like the
Okay.
children are the best interest attorney's client. They
Okay.
examine witnesses. They would ask questions of you and your ex on the stand. A court-appointed advisor is a witness, so their role is very different. They gather information on behalf of the court. They don't work for you or for dad, but they do
Correct.
work kind of for court. They do talk to the kids. They do go to both homes. They do look at records. They do talk to other witnesses, and then they issue a written report and they testify at trial.
Okay.
I think
Okay.
that's a better than a comprehensive family assessment, because comprehensive family assessments are very, very expensive and they take a very long time. And one issue is going to be who's going to pay for that. So you're looking at, I've seen it cost between $10,000 and $20,000.
Okay. And that is not something that's ever ordered by the court. That would have to be done independently by either of the the parties, correct?
No, the court can order it, but they're also gonna have to order somebody pay for it.
Okay.
Could you hear that?
Yeah.
Sorry.
Yeah, I heard that. Okay, and I don't know in this case what would even be better as a best interest attorney or a court-appointed advisor.
It sounds like you need a court-appointed advisor.
Okay. All right. And what type of thing should I present? Like, am I putting in like a petition for the judge to say that again?
It's a motion. So you only file a petition to start the case.
Okay.
So you have a case open. So now anything you ask the court to do will be a motion.
Okay. And what sort of things should I focus on in that motion to present to the judge for that kind of decision?
So what you do is you find the rule that authorizes you to ask. So let me see.
Okay.
If I can real quick.
Is this under like the child's best interest rules?
No.
No, okay.
So we're talking about a rule of procedure. And so anytime you file a motion, which is basically anything you ask the court to do, you have to cite in it the authority upon which you're relying to ask for that.
Okay.
So let's see. Arizona Rules of Family Law Procedure 10. I think it's Rule 10. I'm just making sure. That is the rule that has to do with the best interest attorney or child's attorney. That's Rule 10.
And the same applies for the like a court-appointed advisor?
Nope, that's going to be a different rule.
A different one? Okay.
Mm-hmm. Let me look at 12 and 13. 12 is an appointment of a professional to provide a report or recommendation, so that would count.
Rule 12?
Yeah, take a look at Rule 12.
Okay.
So let me look this up and then I can give you an example of how you write the motion.
Okay. I was going to say, because that would kind of be a blanket one for any professional to chime in, not one assigned by the court.
No, the court appoints a court-appointed advisor.
Okay.
The court appoints the person. Each parent has to pay like $300 usually.
Yeah.
So, and the rule says, whenever there's complicated facts that, require further investigation, and it has examples like, all right, let me look at this. This one that I'm looking at was filed in response to Rule 10.1. There's a pending motion. 10.1 allows the court, and then it has all the reasons that the court can appoint somebody. For any reason the court deems appropriate, the court may appoint a qualified individual as a court-appointed advisor, and then you need the appointment. So everything is in the rule. You cite the rule, and then you say why in this case you meet the qualifications in the rule.
Okay, so I'm just citing the reasons. I'm assuming I'm not like submitting any kind of evidence with that, or do I need to submit that with the motion?
You don't. I mean, like, have you already had any sort of evidentiary hearings?
Kind of. We started with them and we had a best interest attorney, and it honestly, every time we kind of go in there, the judge kind of pushes to like work it out outside of court, which I understand why they do that. So I have a lot of evidence,
Mhm,
and the best interest attorney had a lot of evidence because it's a really complicated case.
mhm.
But at the end of the day, for that one instance, we got that one thing resolved. So none of the other bigger issues have really gone into an evidentiary hearing. And honestly, it's daunting even thinking about that because there's so many issues.
Yeah. Well, you're going to want to write all of those issues down in your motion so that the
Yeah.
court's like, whoa, I can't do this. I do need a court-appointed advisor.
Yeah. Okay. All right. I will get that outlined. Thank you for letting me know what the rule is.
No problem. No problem. Anybody else have any other questions for today?
I have a question, Billy.
Sure.
Okay, so is there anything that I can do? So what's happening is my ex is not taking the girls to like their sporting events. He has his mom doing everything. The mom is like a quasi me, you know? So is there anything I can do? Because I can take them to their things. Would it
And
be
you
a
want
first,
to ask
a right of first?
I mean, yeah, you could ask the court, say, hey, if dad's not able to take the kids somewhere, I'd like the ability to do so.
Okay.
You may or may not get it.
Mhm. And then if I can get, because Emily, since we've been talking, right? When I show up to her games, um, I've told her like, hey, well, maybe we can spend some time when I don't have Adriana. So it would be on a day that's not allocated to me in my parenting plan.
Right.
Is that something that I would have to discuss with her dad? I already know he's going to say no, but should I put that out there if that opportunity does come up where she wants to hang out
Yeah.
on a day where it's just us two?
Yes. Yes.
Okay.
Not because he's going to say yes, but because you're creating evidence.
Yeah. Gotcha. Okay. Thanks.
Absolutely.
Hi, Billy. This is Kendra again. I
Hi.
have a couple general questions. So I'm just trying to envision being in a trial where I'm pro se and my ex has his attorney. In our last trial, he was just awful, like so rude and aggressive, and so I'm just, and I had an attorney then too, so it was easier to deal with. But I'm just trying to envision and I did watch the trial skills, but like when I would do cross-examination or direct, how does that like really look when I'm asking the questions? Do I just like state things?
Of yourself?
Yes.
Yeah. So, you're going to want to have some notes. And you're going to want to say, because usually you're not allowed to testify from notes. But since you're acting as your own attorney, attorneys have notes all the time to remind them the questions they're going to ask. So, you're going to want to have an outline of what it is that you want to say. And then they don't usually make you necessarily go up to the witness box if you're representing yourself, but they might because he has an attorney, and you're in this hybrid role. So let's say you go up to the witness box, you bring your notes, you bring your exhibits, you have to offer to admit your exhibits, you testify, and then the attorney asks you questions on cross-examination.
That's actually another question that I have. So if he is doing cross on me, but I need to object to something, do I just say object like the attorney would, even though I'm the one testifying?
Oh, if he's asking you questions and you want
Right.
to object to a question, yeah, you just say objection, state your objection.
Okay. And where can I get more familiar with all the different objections and
I think
how
we
to
have a
use
course
them?
on that, don't we? Don't we have a course on that?
I did watch the trial skills, but I still just have like deeper questions. So I don't know, is there a law resource somewhere where I can research more objections and how they're
Yeah.
used?
The rules of evidence. So you're going to read the rules of evidence. That's where all of the objections come from.
Okay.
So they're not the rules of family law procedures, the rules of evidence, and then I think there's an objections handout as well in the Navigator.
Okay, perfect. Thank you.
You're welcome.
Can I come back and ask another question?
Sure.
So I'm starting to feel nervous. Like maybe, like, should I be filing for emergency sole decision making? Like, do I have a case? Or
I
like,
mean,
am I better off like waiting for like to just file like regular and go to
well,
trial?
what's the immediate and irreparable harm?
I can't get resources for either of my kids because
Immediate
the
and irreparable. That means somebody's dying unless you get an order. You know what I mean? It doesn't, not necessarily dying, but like almost. Like you need it
okay, yeah.
right now.
Yeah, it's not, I mean, they're not gonna die. He just needs like speech and OT. And then the therapy.
Yeah. I don't think you're going to get an emergency. Sometimes we file it for an emergency even when we think we might not get it because we think we'll get a temporary orders hearing faster that way. So that could be your attorney's strategy.
And what
Although,
does that mean?
well, your options when you want to get an order fast are file for a temporary order and you wait for a temporary orders hearing, or file for an emergency and get an emergency hearing. Now, if an emergency hearing is granted, the other side gets to contest it and you get a hearing very quickly. Sometimes if the court says, no, I'm not going to grant this on an emergency, but I am going to set a hearing, they'll set that pretty quickly. And that's faster than waiting through the normal temporary orders process.
Okay, it kind of sounds like that's what maybe like the plan was. And so then we have him served and then we both go to court and present our findings, or? Okay. Yeah, because I'm not trying to not, I didn't realize that like soul meant I didn't have to talk to him or get, like, I'm not trying to do that. I have no problem telling him and keeping him in the loop and offering to like him to come to any appointment or be involved with selecting providers. But he's just shutting down everything, like doesn't consent to any kind of therapy or resources. So
I
that's where I'm
mean,
like,
he's kind of committing contempt, in my opinion. You have an order for final decision making that he is obstructing.
yeah.
So I might go the contempt enforcement route because I don't know that you really need a modification. You just need him to stop behaving the way he's behaving.
Yeah, but I mean that's like a slap on the wrist, right? So like what happens if the judge grants that or like says he's in contempt and then I turn around and try to get resources and get providers and then he still is giving me the runaround or not agreeing to that provider or not signing the consent forms.
Or
Then I have
not
to pay to
taking
go
your
back again?
child to therapy during his
Right.
parenting time. Then he has to lose parenting time. That's the only thing left.
Okay. So basically just build more evidence essentially.
Well, I mean, if you have a court tell him, stop obstructing therapy, and then he continues to do it, and the court says, you have to take your son to therapy, you have to do what mom says, and he won't do it, then your next step is dad doesn't get parenting time.
Okay. Well, and I know you had mentioned too, one of the times, I don't have it written down in front of, oh, statute, the 25-403.0. No, that's not right. Or maybe that is right. The one that was like saying that he can't
The record?
prevent.
Yeah.
Yeah, but that's what he's doing. So is
Mhm.
that
Yeah,
contempt or what is that considered?
I think it says in the statute, if I remember correctly, is it 403.04 maybe? Let me see.
0.06, I think.
06. All right, let's see. Okay. A parent who attempts to restrict the release of documents by the custodian or attempts to withhold prescription medication is subject to appropriate legal sanctions.
Okay. So
Which
just
is
should I just
whatever the court wants to do to punish you, they can.
okay. Okay, I feel like I need to reach out to my attorney then because I don't think I fully understand like what the strategy is here.
Yeah, that's a good idea.
Okay, thank you.
Yeah, absolutely. Anyone have any remaining questions before we wrap up today?
I've got one more.
Oh,
I'm actually in the opposite situation when our custody switched. Before we had equal decision making, but I had final say and on medical issues. And the reason for that was he was constantly asking for excessive testing and going to doctors even after like everything had presented to him. And then when the kids moved down with him, he had final say because logistically it didn't make sense. He lives in Tucson, I live in Mesa. So logistically he was going to be making those decisions. But it was, joint with him having final say. So we're supposed to have that communication about everything regarding medical issues. Everything else is joint. He's now in that position where he is keeping my older daughter from therapy. He's using the excuse of like, well, I'm in between insurance, and she says she's fine with it. She's good with not going, but she's gotten to the point where she says and does everything to avoid conflict with him because he's very high conflict and there's a lot of guilt tripping and things going on. And so I'm trying to figure out a way to get to court and explain what's going on, that the kids have gotten so browbeaten in the last couple of years that they don't even feel comfortable voicing things like, hey, I've got a toothache, I need to go to the dentist, because they're made to feel like, well, that's not happening. Or, you were just at the dentist, you can't be having that kind of pain. My oldest daughter's supposed to have her wisdom teeth taken out, and his wife is like, well, most people don't get them taken out till they're 21, so it's really not that important. So even though she's having migraines and having pain and was referred out, nothing's happening because he doesn't believe she needs it. I just don't know how to present that to the court because everything that my children are telling me is going on. It's coming from the kids, and he's getting a different story because the kids they're in a position where it's like, okay, you've got to stand up for yourself, but they're kids. You can't tell a kid like go against your father. That's not appropriate at all.
Well, the only one of those examples that's going to be effective then, given all of those circumstances, is the wisdom teeth. Because you can go get the recommendation from the dentist, and then you can reach out to dad and say, listen, she's having headaches, she's having this is the recommendation, why aren't you doing it? And now you're creating the evidence. Because what you're saying is, how do I prove to the judge that what my kids are saying they don't mean? And that's not going to work.
Yeah. Yeah. And that's kind of what we're running into, is where it's like when a child is told so often, like, you can't be feeling this, you can't be thinking this, that's wrong, that's untrue. They get to the point where they're not even voicing their concerns with him anymore because they know it's not going anywhere. So when they're here, they're like, hey, this happened and I told dad and nothing happened. And, so-and-so, this child got into a fight with this child, and the stepmother just laughed about the situation, didn't do anything about it. So it's a lot of really like emotionally neglectful situations that are affecting the kids in a significant way. To like, my oldest daughter had like suicidal ideations and ran away from home, and my other daughter ran away from the home, and I'm not finding any way to help them feel like they're being heard, their voices are being heard, because everything's being squashed so much at their dad's house.
Yeah. And is the case in Maricopa or in Pima?
It's Pinal County.
Oh, okay.
Yes.
I'm surprised they didn't do a child interview, but the court-appointed advisor should be able to get all of that information from your kids and then get it in front of the judge.
Yeah, that was the big thing, because the judge he did say, I will order a child interview, but you both have to waive your rights to see it, because I've seen one too many times where it's used against either parent and against the kid. And I said, I'm fine, I'll sign whatever I need to, but their dad said he wouldn't.
And regardless of whether or not, regardless, that's annoying because the statute says the kid's wishes count. And what the
Yeah.
judge is essentially doing is saying, I'm not looking at the evidence of what the kid's opinion is because dad won't waive confidentiality. I mean, what's the other option? That they come testify?
Yeah,
it's not a
he
good
won't do
rule.
that either. He said, I do not have children in the courtroom. And I get that.
Nobody does that. Nobody does
Yeah.
that. But anyway, all right. Thank you all very much, and I will see you all next week.
Thank
Thanks,
you.
Billy.
Bye.